And we're live. It is Friday, January 21st, 5:04 p.m. Eastern Time. We are not allowed to have fun anymore, and that is especially true today. Not because Anita Krishnakumar is here with us, which is going to be an amazing discussion, but we will be sticking around after the show ends on YouTube to kind of talk about the loss of Chris Argyris, our Greek chorus member who passed away this weekend, and to kind of let everyone kind of just chat about it a little bit. But today, and for this discussion, we have like a really interesting conversation with one of my favorite former colleagues. And I mean, I guess I don't have that many former colleagues. I've been doing this for like 3 years. So, but Anita Krishnakumar is a professor of law at Georgetown, my alma mater. And before that, she was at St. John's Law School with me. And she's an expert in statutory interpretation and empirics. And she wrote an excellent op-ed on Rukeysen's election law blog following Gorsuch's opinion in the OSHA decision. And so we were going to talk about that today. But Anita, welcome to the show.
Hi, nice to see you. Nice to see everyone.
So nice to see you. So do we want to get started with just kind of what exactly was it? Like, I know that you're not a labor lawyer and the OSHA case was a labor law case. But what was kind of at stake in that case exactly? And I mean, I think that this kind of ties into kind of in part why Gorsuch came out the way he did in his decision.
Yeah, so I mean, I think of it as really like an ad law and a statutory interpretation and an employment law case, right? So what's at stake is, can the agency do what it did, and particularly here under a provision of the statute that allows the agency to take emergency action, right? So typically when OSHA promulgates regulations, it goes through the notice and comment process, but that takes a while, and COVID is this, imminent, urgent problem. So OSHA promulgated the regulation at issue through, it was not really through the notice and comment process, through the emergency provision of the statute. And so what the court was deciding, and actually the way it came before the court, is that the Fifth Circuit had stayed that rule, right, that emergency rule, and then the Sixth Circuit had lifted the stay, and the Supreme Court went back and reimposed the stay. So that's sort of the posture, but it's, they really did basically reach the merits in deciding to reimpose the stay.
And just to be clear, the emergency rule was related to COVID, and I think it was if you have over 100 employees, it has to be a vaccine mandate, or you have to test negative once a week, right? That was like that. Okay, yeah. Great.
So what's your beef with Gorsuch?
Yeah.
Well, I mean, look, there's multiple.
He seems like such a nice guy with like
there's
that
whole. I have a beef with him and the per curiam opinion. And there's multiple beefs. I mean, if I put my ad law hat on, I sometimes teach administrative law, which I'm teaching now. Then there's lots of beefs. What I wrote about in the blog post was a statutory interpretation beef. I mentioned the emergency provision. I'm just going to read you that provision of the statute. So the provision authorizes OSHA to issue emergency regulations if it makes a determination, A, that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful or from new hazards, and B, that such emergency standard is necessary to protect employees from such danger. So it's pursuant to that provision that OSHA issued this mandate that if you have for employers who have more than 100 employees, you must impose a vaccine or test requirement, and that can only last for like 6 months because it's an emergency provision, right? So that's what the court struck down. And in this opinion, you would think, I just quoted you some lengthy statutory text, right? You would think that there would be some discussion of the text itself, especially from this court, which has moved so far in a textualist decision, and particularly from Justice Gorsuch, who has sort of prided himself on being a textualist. And yet there's no textual analysis in the per curiam or the concurring opinion by Justice Gorsuch. What they rely on instead is basically a bunch of substantive canons and sort of lurking in the background, the non-delegation doctrine, which this court seems pretty primed to revive. So what they say is this is a rule that OSHA has issued that is going to have such vast political and economic significance, affecting 84 million people. And so given that, that's just too sweeping of a regulation. And we don't presume that Congress gives an agency the power to make that kind of sweeping regulation unless the statute clearly says so. So they impose sort of a super strong, clear statement that unless there's targeted language in the statute, that basically the statute would have to say, and this includes a vaccine or test mandate, right, in order for it to meet that test, which, Congress, statutes are never going to meet that test because Congress doesn't say, and this includes, you can regulate, asbestos, and you can regulate benzene, and you can regulate tractor injuries, right? It doesn't say that. It speaks more broadly. So if you're going to require that level of specificity after the fact, right, ex post, this statute was passed in 1970, then that's going to kill the statute, right? So it's a very substantive policy-based approach saying, given the scope of the regulation that what OSHA is trying to achieve, that's just too much. We presume Congress doesn't delegate that kind of authority to the agency. It's something that scholars have labeled the major questions doctrine, where the court can basically say the regulatory question at issue is so big that we don't presume the agency has that authority unless Congress tells us clearly otherwise, right? And they sort of backpedal that into the non-delegation doctrine, saying if the statute act, if the end of the opinion, right, if Gorsuch's opinion, if Congress did give OSHA the power to do this, that would be unconstitutional.
Okay, so I have like a million questions.
Yeah, go.
and they're intertwined with one another, so I'm going to try to disaggregate them. First of all, it seems to me that what Gorsuch does here is a bit of a piece with Scalia's signing on to the Brown and Williamson majority a number of years ago, where I forget the exact language of the Food, Drug, and Cosmetic Act, but it's something like products that are intended to affect the structure and function of the human body.
Good memory,
right?
yeah.
And intended to affect the structure and function of the human body clearly describes cigarettes and tobacco products, and yet I believe it was a Sandra Day O'Connor opinion, but Scalia, the textualist icon, signed it, and it doesn't ever bother to say, well, wait a minute, that language is obviously encompassing the product in question. That really should be the end of the conversation. And I always thought there was the fact that Justice Scalia didn't feel any need to explain himself in that was a kind of odd betrayal of textualism, right? That, the implication seemed to be, well, we can't just let the FDA assert jurisdiction over tobacco because that would be ridiculous. And so you kind of have this embarrassed silence on the textual breadth. And my question is the silence here embarrassed, or is Gorsuch using the non-delegation doctrine as a way to relieve the embarrassment, saying, okay, we're gonna avoid a non-delegation problem by interpreting this statute less broadly than it reads?
So you're absolutely right to draw a parallel to FDA versus Brown and Williamson. But I think this one is worse. And Brown and Williamson also has a ton, O'Connor's opinion has a ton of legislative history. Like she's relying on hearing testimony rejected.
Right, but Scalia doesn't like legislative history,
not a textualist whimper, as Bill Esper likes to say.
Doesn't concede its legitimacy. I have no problem with O'Connor's opinion in Brown and Williamson for O'Connor.
Right.
I do have a problem with it, except that I think it's wrong. I do have a problem with it for Scalia.
Yeah, no, I agree. So this is not the first time that we have seen a textualist willing to abandon textualist, plain meaning analysis and even embrace legislative history and other things they usually rail against in the service of limiting an agency's regulatory power, right? Or it's basically telling an agency, you've gone too far, you're trying to legislate to sort of the limits or beyond the limits of what we think is reasonable, right? And using this kind of major question idea, because that's one of the cases, the early cases that scholars sort of looked at and said, this is a version of the major questions doctrine, or coined the phrase the major question doctrine to talk about. But I think this opinion is worse because in that one, I think it is a little bit of an embarrassed opinion, right? He's not, and Scalia isn't writing, right? I mean, it's bad enough that he's not writing separately and that he's going along with what O'Connor is doing because he, in other opinions, tends to, dissent from a footnote that mentions legislative history. So it's hypocritical, but he's not the one writing it, right? So Gorsuch writes this concurrence and there's nothing textual in it. And there's a whole heck of a lot of legislative intent and history and other types of, gesturing towards what Congress meant of the kind that he usually criticizes, right, to try to prove his point. So, and there's no embarrassment. There's no embarrassment in the per curiam or the concurring opinion. There's no acknowledgement that the text might otherwise be clear enough to cover this, but for whatever reasons we think otherwise. There's no even attempt, right, to offer dictionary definitions or close textual parsing of these words that are in the emergency provision that I read you, like substances or agents or physically harmful or new hazards. I mean, they could have at least ventured an argument that would suggest.
But it's hard to see how the term new hazard would not cover a novel coronavirus, novel being roughly synonymous with new, and virus being certainly encompassed under the word hazard.
Right. Instead, they just sort of offer us this repeated references to occupational and work-related, and they italicize those words, right? So that I think the implication is supposed to be, and they sort of say it a little bit, that the only hazards OSHA was supposed to be allowed to regulate are those that are directly work regulated, which is totally belied both by the definition of occupational that's in the statute, which was in the briefing and didn't show up in the dissent, but that's labor law lawyers have pointed out. So it doesn't work because of the statute's own definition of occupation, and it doesn't work because of the history of OSHA regulations that have been upheld that includes things that are hazards both within the workplace and outside the workplace, like asbestos, like benzene, like tractor injuries, right? So it just doesn't make a lot of sense. And what's alarming about this opinion is it much more has the feel of this is the direction we're going in now, and we have the votes, and who cares about methodology, and we don't even have to pretend that we care about methodology.
Okay, so second question, and then I will yield to my colleagues. How much of this is really about the non-delegation doctrine? That is, that really what Gorsuch is saying here, when you strip a bunch of, the terminology away, is he's saying, hey, if OSHA is allowed to just say novel coronavirus can get you sick in the workplace, so we're creating a new rule. That's really a legislative act, and rather than saying 1937 too many times in a single opinion, I'm just gonna say I'm just gonna defy the originalist methodology and read the statute much more narrowly than it reads to avoid the problem.
Yeah, I mean, I think that's definitely lurking in the background, right? There's so many things that bother me about this opinion, but one of the things that bothers me about the opinion is that it stops short of really engaging the non-delegation doctrine. Like, if that's doing the work, it clearly seems to be doing a lot of the work, because they talk about what a sweeping rule this is and how it's going to affect so many people and how it's a permanent thing. Like, you can't unget the vaccine if you have to get it because of this OSHA regulation. It's not something you can undo, and so forth. But if they want to go that route, I would rather the court, I think it's more intellectually honest to go that route, right? To say the statute clearly allows this, right? And we think that is too much of a delegation of legislative power that's legislative, to the agency. And then they would have to grapple with things like, does the intelligible principles doctrine still survive? Gorsuch has suggested no in his Gundy concurrence, right? And he wants to return to sort of pre-1935 approaches to the non-delegation doctrine, where the only things that Congress can delegate to the agency is the power to fact find, right? To if you find X fact, you can do this, or if you don't find X fact, you can do this, or to sort of fill up the details, like a narrower power to delegate. So then he should engage those things, I think. And of course he doesn't want to do that. Like they're going to say now in 2021, 2022, after 52 years of OSHA being in effect, that this is unconstitutional, right? They don't want to do that, right? So I just find that so intellectually lazy and kind of sloppy to be like, just throw it in there in the back end as an extra reason, right? Major questions is doing the work, but if we were to find that if Congress had actually authorized OSHA to do this, it would be unconstitutional too, but never mind, we're not going to give you that analysis. Like, it's just another reason to cringe at this opinion.
There you go. Oh, sorry, I was unmuting you, Genevieve, and you were unmuted yourself at the same time.
It happens. One of my quick questions is how, while it's intellectually dishonest in terms of the argument in general, constitutional theory and analysis, is it really that surprising considering Gorsuch's history as a jurist and his antipathy, almost blatant dislike of Chevron doctrine and administrative law? So what should we be watchful for? Because I can't imagine that others, even in the conservative bloc, feel exactly that way. A lot of them kind of share more of a Justice Scalia perspective, where he was pretty deferential, Chevron doctrine, to the administrative state. So I'm just
sure. So it's not surprising, right, at all. I mean, I think Gorsuch is pretty hostile to the administrative state. I think President Trump sort of openly looked for judges, right, to appoint to the Supreme Court who were pretty hostile to the administrative state and who really questioned its constitutional validity. And I think we're seeing the consequences of that. On the Chevron question, it's interesting. So the major questions doctrine sort of comes in that sphere, right? When the first few cases where the court started talking about it, MCI in the 90s and then FDM versus Brown and Williamson in 2000 were some of the early cases. What that allowed the court to do in those cases was to avoid Chevron deference, right? To say, even if this is a case, it allowed the court to do two things: to take statutes that were pretty broadly worded and seemed to allow the agency to do what it did, at least under a Chevron regime, and to just say Chevron doesn't apply here, basically, right? Because this question, the subject matter on which the agency is regulated is so broad and of such vast political and economic significance that we can't assume that Congress delegated the authority to the agency to fill in the gaps here, right? And that's what Chevron is based on. So if Congress didn't delegate that authority to the agency, then we don't use the Chevron doctrine, right? We decide ourselves that we can't. That the presumption is that Congress didn't give the agency this authority. But it's in this opinion, I think, in this case, the court is even moving beyond that, right? And Gorsuch gives this detailed, lengthy discussion of the major question doctrine that almost like weaves it into together with the non-delegation doctrine. And so I think it's moving in a different direction. And I think what's also interesting is you mentioned Justice Scalia. Scalia evolved. I think on administrative law questions, he was very much a proponent of Chevron for a while, but towards the end of his life and his career, he started questioning Chevron and moving towards a more formalist argument that Chevron isn't authorized by the Administrative Procedure Act, or it's intentionally detected.
He loved Chevron while Republican administrations were
that's
agencies.
The truth.
That's the cynical way of looking at it, Ben. You don't have any reason to believe the cynical.
I'm not a cynical person by nature, and I try to resist in statutory interpretation the partisan ideological view of most cases, and I mostly am able to do that, and I think that does describe most statutory interpretation cases. But then in the high stakes cases, it's very hard to avoid that conclusion, and when the court totally avoids the textual, even the attempt at a textual analysis in a case like this, I think there's reason to believe that it's entirely partisan. And there have been studies done of both at the Supreme Court and the Federal Court of Appeals level, I think, that show that voting in terms of agency deference is very ideological, that Republican appointed justices and judges tend to defer to agency interpretations under Republican presidents and not under Democratic presidents, and vice versa. So you're not wrong, Ben.
Scott, go for it.
Okay, thanks. I think I agree with everything you say, except for one thing I don't understand is, what is OSHA?
What is OSHA?
Yeah, that was a joke.
OSHA, Scott, are these big bodies of water that between the continents.
Orcas.
I just don't.
You know.
It's the plural for oceans.
So two questions. So one is, what's with the per curiam business? Can you explain that? Like, first of all, like, the court's doing this a lot, and like, why did it do it here when you had like 3 concurrences, 3 dissents?
Yeah, I don't know why they did a per curiam. I don't have a great explanation for that. I mean, I think it's probably fair to speculate that it wasn't written by, Alito, Gorsuch, or Thomas, and was probably written by Roberts or Kavanaugh. But I'm not sure why they did it as a per curiam.
Okay, that's just.
Sorry, I don't have a good answer to that.
No, sorry, but I want to answer, like, I don't get the whole strategy. So I get the strategy, which is like, you don't like the administrative state, you're going to cut back in all these different ways, through non-delegation, through major questions, like they're just doing it in all these different ways. But I mean, this is my question to you, which is, because at least to me, it feels like trying to like sweep back the ocean, if that's the expression. Like, it's just like, the agencies are going to produce.
I think you mean sweep back the ocean.
No, the singular of OSHA is the OSHI.
Okay. I think it's OSHA, but because it's male, but yeah, no. Like, so you can. It works like on these culture war, big ticket type things like vaccine mandates or something like that. But like for the general, regulatory landscape, regulation printer go burr. I mean, does it feel to you like that this is not, you can't really rein in the administrative state at this point?
So this is why Ben's comment is important, and what's one of the things that's really frustrating about this. Yeah, we're not going to completely eliminate the administrative state. What it lets them do, though, if they're able to use things like the major questions doctrine and the non-delegation doctrine to sort of cut off the power of the agency to regulate in certain areas or in certain, an ad hoc basis to decide that went too far, is it gives the court more power, right? It enlarges the discretion of judges, because the major questions doctrine is policy based. You're deciding based on the specific policy and the specific thing that the agency is doing, right? So when they like the regulation, like when it's from a conservative president, they can say, "Oh, this isn't too big of a question."
No. So all I mean to say is that when you have, so the good thing about, from your perspective, from wherever you sit, enlarging discretion is good from the perspective of you getting to strike down the things that you don't like and upholding the things that you do. But on a kind of at scale, discretion doesn't actually cut down regulation in the way in which you would want from a political point of view that was really anti-regulatory. So it seems like it feels like whack-a-mole, and it just that's what I mean to say.
Yeah, it's but it's a kind of nefarious whack-a-mole, right? It's not like we're just trying to cut the legs out of the administrative state every which way we can and as much as we can. It's very calculated and sort of policy based. But yeah, you're right. They're not going to completely eliminate it, and nor do I think they want to.
But
there's some agencies they like less than others. So maybe we'll see less deference to particular agencies.
I mean, I wanted to say, in defense of the conservative project on administrative law more generally. Leave aside it in the current moment.
Mm-hmm.
Chevron was itself written by Scalia, a response.
It's written by Stevens.
But with
Majority.
Scalia on it, right? He's part of the Chevron majority, I think.
I don't think he was on the court. I don't think he was on the court.
I don't think he was on the court when Chevron was
I don't think he was on the court yet. It's a Stevens opinion.
I'm looking it up. It is. He was not on the court. I'll look it up, but go ahead.
I don't think he was on the court for a couple more years.
But Chevron is itself a response to the Warren Court and Burger Court era's propensity to jump in and reinterpret statutes kind of over the agency's objections whenever they kind of felt like it, right? And so there's risk in the other direction as well.
So I'm not sure about that. Like, I actually think, Chevron, I mean, and I don't know the history as well as some folks who've done their research on it, but I don't know that Chevron changed the rates of agency deference all that much. I think what it did was to provide more of a clear-cut test, which is why Scalia embraced it for so long, because he loves clarity and he loves doctrines that are, do this, do that, and we know what to expect. But I'm not sure. I think there's research out there that suggests that it didn't change the rates of deference to administrative agencies all that much, actually. And there's research suggesting, between 1984 and 2006, that the court didn't actually invoke Chevron, at least the Supreme Court didn't invoke Chevron in all the cases where it maybe could have or should have. It used other deference regimes, or just didn't mention a deference canon or regime. So I'm not sure that that's true.
Okay.
So really quickly, and it might be slightly deck chairs on the Titanic, given how much we've talked about kind of a lot of very specific ad law and con law terms. But would you mind just giving us kind of, I mean, you of all people are just awesome at this, giving us kind of an idea of the canons of statutory interpretation and where textualism fits in and why textualism here is at the crux of kind of I don't know, Gorsuch's canard, so to speak, why this is the thing that he's kind of manipulating to make his case to the people that he's trying and the audience that he's basically shooting for by using textualism.
Okay, so first, statutory interpretation 101, right? So the canons. I and a lot of people like to think of the different canons or tools of statutory interpretation that are out there as falling into three buckets. So one would be sort of the textual canons and tools bucket, which involves things like just looking at the four corners of the statutory text, the terms that are in the statute, closely parsing that, figuring out what the ordinary meaning or plain meaning of the words is, maybe looking at them up in the dictionary to support what you think the ordinary meaning is. Also entails a bunch of sort of logic, grammar-based, structure-based arguments where you might look at how the sentence is structured, grammar rules, about commas and last antecedent and verbs and what tenses they're in, etc., as well as some Latin canons that are really logical inferences, like if the statute specifies X, Y, Z items and leaves out ABC, then the presumption is that ABC were intentionally left out. Looking at the part of the statute that's an issue in light of other parts of the statute, right? If there's differences in language between two very similar provisions.
Does it include looking at the legislative history?
No, not at all. So it's
okay. That's what I'm.
So these textual canons are all focused on the four corners of the statutory text. Then the second bucket is sort of a bunch of extrinsic or reference canons that involve going outside the four corners of the statute to things that other institutions have said that might impact or inform the meaning of the statute. So that includes legislative history, right? Because it's written materials created by Congress, right? It's not just loosey-goosey, right? It's something that another institution has said about what the words in the statute mean. Common law, right? So what have earlier courts said? Is there a common law definition of the word that's used in the statute? And should we presume that Congress incorporated those common law meanings into the statute? Other statutes, so there are other federal statutes that use the same or similar phrases, and especially if they're on the same subject area. So another criminal statute, if you're looking at a criminal statute, although I've written about this, the court a non-trivial percentage of the time goes to other statutes that have no subject matter relatedness to the statute at issue. But figuring out, okay, in another context, the court said because of means proximate cause, right, or but for causation. So that's the rule across all statutes, things like that. And then the last category are substantive canons, which are policy-based canons that the courts have come up with themselves, right? So they're not tethered to other written things created by other institutions, like the extrinsic canons. They're not based on the four corners of the text. They're based on, principles of American law that come maybe from the Constitution, maybe from common law, maybe from our Anglo-American tradition, but they're very policy-based. Yeah, Blackstone can also, feed into the common law, but yes, often from sometimes property law, right? The court will cite common law rules about easements to help it figure out the meaning of a statute and how it applies with respect to an easement in a particular case. So the major questions doctrine is very much a substantive canon, right? Because it's putting the thumb on the scales in favor of sort of one outcome or the other, deference to the agency or non-deference to the agency, based on this background norm idea of we can't have too much delegation to Congress. Okay, so your larger question was, where does textualism fit into all this? So textualists are very focused on and happy with the textual canon, all the tools that fall in that bucket. They're also happy with pretty much everything in the extrinsic source bucket, the things that go outside the four corners of the text, except legislative history, right? And they're also very happy with substantive canons, which are like made off the top of the head by judges, right? So the only thing they really object to is legislative history. And you might ask why, and everybody has their theories about this, but I think a part of this is, very logical, makes a lot of sense. I think Justice Scalia and some other textualists were reacting to the way the Warren and Berger courts did statutory interpretation in the era of the 60s and the 70s, which was sort of all over the place, right? Legislative history was kind of a free-for-all. They were just finding whatever they could in there that might sort of support what the outcome that they wanted to reach, arguably, right? There's very loose sort of purposive analysis. There isn't careful use of legislative history. There's, just looks like sort of making stuff up. It's a little too loose, and I wouldn't argue that we should return to that era. I think Justice Scalia was right that we should focus on the text more, and I think he did a good thing for statutory interpretation by focusing people more on the text and focusing people on the dangers of misuses of legislative history. I just think he went too far in wanting to chop it all off entirely. And it's just very curious when you study this stuff, how textualists are willing to look at everything else, including these other extrinsic sources, right? Including substantive policy-based canons that judges made up, right? But no to legislative history. It's sort of a basically cutting Congress out of it, right? Anything that Congress said about what the statute meant, we don't want to look at it. And I think it's a product of its time, and that textualism came up in reaction to the purposivism that was used in a very ideological way in the 60s and 70s. And I think there's no reason that textualism has to be, if you're really following it, ideologically conservative or produce conservative outcomes, right? And that's where I think we're running into problems now, right? As the court has become more and more textualist, there's a movement of progressive textualists, right, who are looking at these older statutes like the OSHA Act, like Title VII, like the ADA, and saying, we can make arguments that are purely textualist for why this statute covers the things we want them to cover, right? And that's where the rubber meets the road for, are you really a textualist, or are you a conservative who's using textualism to promote your ends? And I think we're seeing the latter.
All right, so I want to defend Gorsuch a little bit on this front, because it seems to me that in two very major cases over the last few years, he has actually lived textualism at the expense of where all the other conservative justices are. One of them, of course, is the application of non-discrimination law to not merely to gays and lesbians, but to trans people as well, based on, which is not somewhere that the rest of the conservatives were willing to go.
Well, Roberts
was willing to go there, yeah. But it is something that the advocates were able to frame in a explicitly textualist fashion, and Gorsuch was willing to go toe-to-toe with Kavanaugh and Alito over it, coming to a quite liberal outcome in a hot button culture war issue in the name of his ideology. The other example that I think is in some ways even more striking is McGirt, which we have discussed on this show, not in a textualist context, but again, here Gorsuch sides with the liberals and turns over literally half of the state of Oklahoma to the tribes because of his understanding of the absence of an explicit congressional revocation of tribal sovereignty. And so when you see him being true to the ideology in cases as high stakes and substantial as that, and yet as flamboyantly untrue to it as you're describing him being with respect to OSHA, it seems to me there's three possible conclusions from this, and I'm curious which one seems to you like the reality or whether it's something else entirely. One is he's a genuine, sincere textualist, but he's a flawed human being, and like all human beings are flawed, and sometimes, like all of us, his knees jerk, and when his knees jerk and he betrays his or fails in his ideological, philosophical convictions, they jerk to the right. So in two of these three cases, he's true to himself. In one case, he's not, and you get the conservative result. Second possibility is he's actually an ideological prostitute, like a lot of people in the Greek chorus are saying in the chat, and he just cares more about administrative law than he does about anti-discrimination law or about the tribes. And by the way, he's from Colorado, and he has clearly has a certain sympathy with the tribes. So maybe that's actually an example of him being him getting the result that he wants using textualism. And then the third possibility is the N is too small to make any judgments here. You really have to look at somebody's commitment to these things over the scope of their career. And really, one OSHA case in a non-precedential context is an area where you would kind of expect somebody to fall down. It's a hot button issue. It's there on the shadow docket. And so we just shouldn't read too much into it one way or the other. What do you think? How important is this failure of textualism, and where does it fit into a larger career pattern on his part?
So I think that's a little bit of one and two of what you said. Some of this is just guessing, and we have to see things play out, and I can never know the answer unless I've got inside Gorsuch's head. But I would suspect it's a little bit of the first and second thing that you said. So I mentioned before that I tend to resist the partisan and ideological explanation for most cases, and I think in statutory interpretation, that is true across the board, right? So I've been documenting and studying empirically the Roberts Court statutory cases since 2006. I have something like over 600 cases in my data set. And almost half of those statutory cases are unanimous at the Supreme Court level. So that means even though there were often circuit splits, right, for it to get there. So almost half of those cases are unanimous. There are a lot of cases that are about things like ERISA and FILA and, just a bunch of other statutes that are not politically high stakes, that are not salient or visible. And I think the court has an easier time, all of the justices sort of coming to the same interpretation, right, in a lot of those cases. And even when they disagree, there's sort of interesting fault lines and interesting bedfellows. As I think a lot of people know, Scalia was big on the rule of lenity, even though he's not pro-defendants generally, right? So that's one of the things that I like about statutory interpretation. I'm pretty I think if you were to do a psychological breakdown of me, like I like clear rules too, and I think textualism appeals to me in a number of ways. I just don't find it to be determinate the way that textualists claim it is in a lot of cases, and I see a lot of sort of funny business when you claim that it is. So part of my project has been to put on the table the discretion that exists in a lot of these textual tools, and to try to push for maybe meta rules or things that the court could adopt so that it would be more constraining than it is in the way it's practiced. So that's all a roundabout way of saying I think it's possible that there are some cases in which the judges care more, that Gorsuch might care more, and I might suggest that McGirt and the Bostock case might be cases. I don't know, but they might be cases where he was also ideologically okay with the outcome, right? And or more okay with the outcome than maybe he is in other cases. I think administrative law is one of his sort of like pet projects, and I think there's you mentioned you have the strict scrutiny shirt on, so I'll say I listened to the episode recently, and I think they were joking that he's right. I need to make a statement about the administrative law case. So that could be part of the explanation. The other thing is, I think in Bostock, I know the Bostock opinion better, more inside and out than McGirt, so I'll talk about that one. There's a lot going on in that opinion. It's not just text, right? Gorsuch is relying pretty heavily on precedent, and I joined one of the briefs that argued that based on a purely textual analysis, the scholars' briefs, that a purely textual analysis required the outcome that the court ultimately reached. But I actually also think it's text plus precedent that makes it a slam dunk, because there's just a series of cases where they held that Title VII covers things like gender nonconformity, right? So once you get that, it's pretty hard not to say that it doesn't extend to sexual orientation and gender identity. So yeah, I guess those are a couple of thoughts I have on it. And I think if we, in terms of looking forward, what we should expect from Gorsuch, I think he is a committed textualist. I think he is not just signing on to textualism because he wants to reach conservative outcomes. And I think, there are going to be cases where he is willing to reach the more liberal outcome. But I also suspect that when something hits really close to home, he's going to have a hard time. And maybe all of us are like that. We're all human. Like, I don't think it's possible to interpret a statute with, completely separating out
everything about your humanity. Yeah. I mean, this is, I mean, in a way, this is kind of like also a commentary on the objective reasonable man and like the objective person analysis and everything else. Like, there is no such thing, and never do we. Yeah. So no, I totally agree.
I just want to, before we go to audience questions, I just want to foot stomp that point a little bit. I actually think Gorsuch is a sincere textualist, and I think he is not a prostitute for conservatism. I think he is a conservative, however, and I think one of the reasons that I agree with you that his performance in the OSHA case is so disappointing is that when similar conflicts between his apparent ideology and his textualism have arisen before, he has been kind of admirable about saying, well, I guess you got to return Oklahoma to the tribes, and I guess because of sex has to include trans people, and and I think he's been actually relatively courageous in that regard, in just kind of shrugging and going where textualism leads him. I'm not myself a textualist, but and so I think that makes it very striking when he doesn't do it in a very glaring way like this one. Mm-hmm. But I would kind of defend him in general as like somebody who kind of puts his money where his mouth is on that, even when it at times leads him to sort of absurdities.
Yeah, he's not Justice Alito or Justice Thomas, who are always going to reach the result that they want, right? And who are going to be and Alito in particular, I think, is just all over the map in his methodology. So I agree with that. And but sort of on this point, like Kate was saying, that it's not possible to be completely objective. And I think a lot of the work that I've done and sort of the underline or the bottom line of it has been all of these methodologies are none of these methodologies. All these methodologies are going to allow judges to continue to decide cases in part based on their the preferences, right? And we all bring our own pragmatic biases to even the reading of the text. That's why different people get different ordinary meanings and plain meanings, right? So the best thing to do is to try to sort of cabin our own policy preferences, or to check our own policy preferences and the pragmatic experiences that all of us bring to the reading of a text. And that's why at the end of the day, I'm not a pure textualist, right? I would say let's start with the text, but we should look at everything else to sort of, and look at it with the eye of trying to disconfirm our first gut reaction, right? Knowing that we all do this. And to the extent that you can do that, I think that's the best approach for all of us to take, and to recognize that we're not going to completely eliminate this. But it really bothers me when people say, well, this methodology is going to eliminate it more than this methodology, because I just don't see that.
No, I think that, that piece of it is anti-intellectual and dishonest in like a way that is unhelpful, and I agree with you completely. But we have to go to, I'm hoping to get into audience questions because there's so many that are excellent. But Michael McKenna, the floor is yours, friend. Thank you for being so patient.
Oh, no problem.
Hi.
My question is, Justice Gorsuch has previously ruled that leaving a broken truck in a blizzard to save your life is a fireable offense. Does he think employees have any safety-related rights at all?
Oh, that's like a really
not a loaded question there, even a little bit.
I liked the loaded question. I thought that this would like rise to Anita's point. Sorry.
Yeah, I'm not sure. I'm not sure he does. I mean, like I could get inside his head, but I find that to be a crazy interpretation, right? I mean, that's insane. So yeah, maybe he's going to go all the way down with that, right? And maybe that's an example of him sticking to what he thinks this text clearly demands, even though it's an absurd result.
Richard Wattenbarger, the floor is
all
yours.
Bundled up. Is your heater out?
Yeah, I know. You've got me nervous that like your heat's not working or something, Richard.
Well, I'm in the coldest room in the house, and it's cold here in Philly today. So, we know that, and Anita, and you've pointed out that there are cases in which textualists aren't able to maintain their textualism consistently. And so I was curious really about, over the longer term, do you have a sense of what Gorsuch's history has been on this? I know we've touched on this some in part. And is it likely, do you think, or how likely or plausible is it that conservative justices might end up eventually torpedoing textualism, not because they aren't professing to be it, but people around are going to see, wait a minute, this seems to be a bankrupt way of going about things?
So that's a great question. I'm going to start with your second question, your larger point question. I have actually been thinking lately that I could see, I mean, it's like we're in cycles of statutory interpretation, right? Like in everything else. I think Scalia and others who were promoting textualism in the 80s and 90s and last 20 years were reacting, as I said, I think, to the sort of overemphasis and loosey-goosey use of purpose and legislative history in the 70s. But I think we're coming to a point where and it was good that they pointed out the abuses of legislative history and purpose and focused everyone on the text again. But now I think we're coming sort of down the mountain, right on the other side, where we're going a little too far. And I've been thinking lately that what kills textualism possibly could be this sort of progressive textualist movement, right? It's sort of exemplified by the Bostock case. And now you've got 6 out of 9 of the justices who are textualists, but more conservative first, I think, at least some of them are. And so, I could see textualism actually dying out because of that.
Can I say there's the alternative explanation as to obviously why textualism is going to die out, because once you've captured the judiciary, you don't need it anymore.
Yeah.
That's the.
I love this point.
Yeah, I mean, this is in some sense the point. I mean, almost that Adrian Vermeule is like openly.
Authoritarian about?
Openly celebrating. Yes, we had
It's
to
the
say,
I've got the power
Yeah.
principle.
Yeah,
I
right.
mean, that's what this opinion reads like, right? The OSHA
Yeah.
opinion. Yeah.
so then it'd be like, yeah, you're right. All those philosophical arguments that many have been saying over the last 70 years about textualism, it turns out that they were right, and really what we really should be focusing on is the common good, and this is the the return to the Warren Court, except the bizarro Warren Court.
I still would love to have Adrian on the show. I think. No, I think we need to. I'm going to re-invite
He doesn't
him.
say yes, in my experience.
No,
Doesn't he block you, Ben?
He doesn't. He really doesn't like me.
Yeah. So that sounds fun.
I guess
Let's
I'm a
invite
rhino
people
or
that hate
something.
us onto the show. But I was going to say, so I've been trying to get Charles T to come on and ask this question, but I'm actually going to broaden it. So he wants to know if you think what you think the future of OSHA is after this. But I think the far more kind of pertinent question is not really specific to OSHA at all, but the administrative state. And so I'm curious what your thoughts are. If this is, as Scott says, kind of like the end, like the last gasp in a way of textualism, as it kind of, I don't know what the right word is, captured, or as it captures the judiciary and then it dies out as a pretext, right? I don't know. What do you think? What do you think or is it just going to make the administrative state even more politicized than it already is? As you kind of said with Scalia, that this was kind of that there was writing on the wall for this far before it was captured by the judiciary right now.
Yeah. So, I think the future of the administrative state, I think this is a worrisome opinion, right? And it's not the only one. This has been coming for a while, but I think it's sort of the way it's written and the emphasis on the major questions doctrine and wrapping it in with non-delegation. I wouldn't be surprised if within the next year or two, we see the non-delegation doctrine being revived more openly. And I think that is going to lead to a lot of narrow reading of the authorizing statutes and the scope of authority that agencies have, especially when it's agencies that the court doesn't like, right, and regulations that the court doesn't like. But across the board, it's a doctrine that, and it's been coming on for a while, right? The major questions doctrine is a couple decades at least old. But it's a doctrine that allows the court to ignore the text of the statute, right, and to just say, based on a policy evaluation, that this question is too big to parse the statute closely or to assume deference to the agency. So I think we're going to see a real shrinking of the administrative.
Can I ask if there's been the death of other doctrines that this is not my area. Was there a McCarthy doctrine that was are you a communist or aren't you a communist? The end of the I don't know. Was there what were the other were there other doctrines that have died?
You mean other canons or
canons? Yes.
Yeah. So Aaron Brule has tried to write about this, and I think he writes about the jurisdiction canon. He's sort of a Civ Pro person, so it's kind of connected to that. And I can't remember in detail what he says, but he's been trying to look into this. I can't think of anything that's really huge. There are canons that remedial statutes should be construed liberally that no one has cited, in the Rehnquist or Roberts courts, so for a pretty long time. So canons do come in and out of favor, I think. But this is kind of a bigger deal because it goes to the heart of the administrative state. And then I think you asked another question in there, Kate, that I forgot it. No,
I don't think so. That was kind of, is there, basically my question was if the text, as kind of Scott is suggesting, that there's maybe this is the last, but this is kind of the end of this doctrine, or a canon, how does it die? Basically was my question.
I think
what does it actually look like? And does it lurk forever? Is it taken up by some 1L or 2L at Yale Law School? No offense, Scott. And they they decide that they're going to revive the textualism doctrine 25 years from now? Like, I don't know.
Yeah, I mean, I think things are going to die by disuse, and there'll be no fanfare and no calling attention to it, largely, unless, an academic writes a law review article that nobody reads about it. So, and then that makes it possible, right, for someone to revive it. I mean, when I took administrative law 20-some years ago, and everyone was saying the non-delegation doctrine was dead. When I started teaching it in 2011, we were still saying the non-delegation doctrine is dead. It is not dead, right, anymore. So, I think things can come back, especially since there isn't typically a opinion overruling it. And even if there is, there's Schechter, there's UCAS, right, overruling Schechter Poultry, and yet still the non-delegation doctrine is back. So I just taught it in my class yesterday, and we were looking at cases where the court is just talking about how all these times the court has upheld really sweeping delegations, and there's an opinion that we teach where Justice
that FCC authorizing statute that says the FCC can issue any regulation that's in the public interest. It's a pretty. The Federal Communications Act is no joke in the scope of its delegation.
The casebooks still have a couple cases in there that have a dissent from Justice Rehnquist, where he would have struck something down based on the non-delegation doctrine, or Scalia would have. And they're in there sort of to say, look at this. Is this a 7-1 opinion or an 8-1 opinion? This is like a minority viewpoint that's just a little effort to revive the doctrine that nobody else is willing to go along with. So that's the history of this, right? So I think anything can be revived.
Yeah, I whenever I think of that, I think yes, we can. So.
Wait, like Rosie the Riveter?
No, like somebody else.
Says the Angry Feminist podcast.
Sorry.
You go straight. He makes a Barack Obama joke, and you go straight to the Rosie the Riveter.
Wait, your first generation feminist kind of joke. Yes, I agree. Scott, great reference. Anita, this is awesome. Thanks for coming on the show.
And you're a great American. Thank you for joining us.
Thank you very much.
And tell your daughter it was lovely to have the background music. I'm a little sad she can't play you out right now, but that's
her lesson ended a little while ago. Sorry about that, everyone.
Yeah. Well, it was great to see you, and everyone will be back on Monday, but feel free to stay local on In Lieu of Fun in the Crowdcast to kind of talk about Chris. And we're going to dismiss Anita and close the YouTube channel. But Anita, this is great. Thank you so much. It was great to hang out with you. And we'll talk soon. Bye, friends.
Bye-bye. Thank you.